Good afternoon, everybody, and welcome to this Eversheds Sutherland PROPcast, our monthly client training session on real estate issues. My name is Caroline Andresia. I am the professional support lawyer to the real estate practice group here at Eversheds Sutherland, and I'm joined this morning by Jane Spears, who is a principal associate from our Manchester office. Good afternoon, Jane.
Hi, Caroline.
Today's topic are considerations of co-working. As in-house counsel, perhaps as general advisors, as surveyors, it may be that you are proactively considering a co-working flexible occupation arrangement. You may be looking for what the trendies call agility in the portfolio, or it may be that you have simply discovered that your organisation already has co-working arrangements, formal or informal, in place across the business. We frequently hear from people who say it seems that, for instance, my IT function have now moved in to a supplier's offices for a few months and taken a few desks to work on a project. So sometimes you hear about it in advance as part of a structured strategy, and sometimes it's more ad hoc and informal. But there is no doubt that the demand for all kinds of flexible workspace arrangements in all their forms and in all their lengths and all their types is on the increase, which is why we thought it would be a good topic for a PROPcast this month. So I'm here with Jane Spears from our Manchester real estate team, as I mentioned, as Jane has had plenty of experience in these co-working arrangements. So Jane, sort of question number one then. It might seem like a noddy question, but let's make sure we all know what we're talking about. What do we mean by co-working?
So, Caroline, I would say that there are three types of co-working. The first of which is working alongside others from different organisations with no defined space in a shared area with shared services. This is current and on trend, and it tends to be the image people think of when they think of co-working.
So that's the trendy offices with, slides between floors and a ball pond and really good coffee and beers on a Thursday sort of thing.
Yes, that kind of thing.
We can all dream.
Yes, that's not what our offices tend to be like.
No, nothing like that in Wood Street.
The next type of co-working that we come across is serviced offices. So this is the more older traditional style arrangement where offices are for hire on a temporary basis with services provided, and the occupier is given space in a building, but they can't say which space they're going to have, and they may be moved by the provider on a daily basis or on a weekly basis. But the space is for their use exclusively for the time that they hire it.
So that's the kind of situation where you would go and say, I need an office and a meeting room for this week or something like that.
That type of thing.
Okay, I've got a conference to organise and can I use this space for Tuesday and Wednesday, something like that. Right, got you.
And then the third option that we come across is a bit of a hybrid of the two. So that's flexible leasing. And that's of most interest in the market demand by the big corporate occupiers. It is for shorter terms, has a capped occupancy cost, and it's selling the dream and the atmosphere of co-working alongside that security of space.
Okay, so why do people look for co-working arrangements in the first place? Why the popularity?
Lots of reasons, and different businesses will have their own reasons for going with one of these options. One of them is it allows businesses to set up quickly in a new market. So if you're traditionally based down south and you want to move up north, it allows you the flexibility to go in, test the market, see what happens. Another scenario is you may have a particular project going on within your business, and you know that you need additional space for a particular period of time. Another possibility is, as a business, you are relocating and you need some temporary space to house staff whilst that relocation goes on, either additional staff that you've recruited or perhaps there's some kind of gap in relocating. One of the other things that we're seeing a lot with our corporate occupier clients is the desire to outsource the real estate and the property management function. So this flexible co-working option allows a turnkey short-term lease all fitted out to your brand without any capital expenditure up front.
So that's just a sort of, walk in the door and it's all set up for you, having outsourced, offloaded, somebody else takes responsibility, that kind of, still a lease but still your property.
Yeah, so turn up, plug your laptop in and away you go.
And hope it works. Yeah. Okay, so actually as a real estate lawyer though, which ones do you most advise on? Do you see all those agreements, some of them more than others? Where are people and clients coming to the lawyers for advice?
Yeah, so we do see some more than others. In terms of the truly casual co-working arrangement, so that's where it's a few desks at a table or in a booth rather than a particular defined space. They tend to be commonly referred to as a membership agreement, and they're more of a commercial contract rather than what we would see as a traditional real estate document. Those tend to be very simple, plain English, user-friendly, and that's what the providers are looking for. So in the real estate practice group, we don't tend to see those as much, simply because of the nature of the document, and those are normally dealt with in-house. However, we would always suggest that you check for notice periods, for termination, any additional costs that may be built into using the space, rules and regulations, and terms around fair usage, so making sure that the space is shared with all the users of the space.
So those are sort of contract documents, they're not property rights, more commercial agreements between the two, and the rules and regulations are about presumably how you use the space, how much space you take up, how many dogs you bring to work, how many beers you drink on a Thursday.
Yeah,
that kind of thing.
Right,
okay. And the next thought?
Yeah, so if we look at then the hybrid model of the serviced offices, so we tend to advise on that type of arrangement a lot more frequently. We would say that the typical customer of that space is a corporate occupier, and we act for a lot of corporate occupiers. And because these arrangements are typically for a longer term and those businesses have a demand for greater space, it's this type of arrangement that also throws up the most legal issues and concerns, which we're going to come on to talk about separately later. The third arrangement of flexible leasing, so this is where you have flexibility as to the terms and the space, the instant availability. It's a one-stop shop and a one-occupation cost. There are still legal issues, so statutory, case law, things that you would consider with a lease to consider when entering into this type of arrangement. And if you would normally rely on outside legal counsel to advise on your leasing arrangements, then we would say it shouldn't be any different when you're entering into one of these type of arrangements, particularly as if the landlord is carrying out works for the tenant to fit it out for its particular specification and brand, there might be arrangements around that as well.
So that's more traditional real estate legal advice,
yes.
The third one. Right, okay. So actually then what kind of advice are you giving? What are the most significant real estate legal issues to consider when considering co-working? What is the most concern from a real estate point of view of law when entering into this kind of new arrangement?
So one of the first things that we would always consider in any of these types of arrangements is whether the document is a lease or a license, and considering the distinction between those two arrangements. This is a long-standing legal conundrum, and it has significance because of the different consequences and protections that follow from an arrangement being a license rather than a lease, or vice versa. And then there's the hybrid arrangements of the middle ground of co-working, which basically make it really difficult to distinguish between a lease and a license.
So if it's actually important to know as occupier whether what you've got is a lease or a license, and because these documents often, have considerations and characteristics of both leases and licenses, how am I going to work out which it is?
It's a really good question, Caroline. We would say you have to look at the intention of the parties around the documentation. So it might make a difference to how the parties refer to their arrangement, but it might not. So a document can be called a lease or a licence, and often those terms are used interchangeably. There's quite a lot of case law on the lease-licence distinction, and it's still happening today. The leading case on this is Street and Mountford, and this goes back to 1985. And there's a line in the judgment of that case which says that the manufacture of a 5-pronged implement for digging results in a fork, even if the intention was to make it a garden spade. So if you call an agreement a licence, and the trend for the co-working situation is for providers to hope that these arrangements are licences rather than a lease, it's not always the case.
And there's still a lot of lease and license case law about, isn't there? I mean, it's not just of academic interest, it's not just a university question. There is still quite frequent case law, and because of the significance attached to the differences. So I think we see that quite often, and sometimes the cases are really hard to call on whether something is a lease or a license. So, that's a tough one even for professional support lawyers. So what else should we be looking out for when making that decision?
From a legal perspective, we would say that the significant difference between a lease and a license is the concept of possession. If the person in occupation has exclusive possession of the area in question, then that arrangement will be a lease. Possession isn't a defined term, but it is the ability to exclude others. You have control of the space, who comes in and goes out, and it's a question of degree in each case. So for the hybrid co-working arrangements we most advise on, this is an important judgment call for businesses and lawyers to be involved in.
And then very different between the different types of co-working that you mentioned. Nobody can say they've got possession, presumably, if they just rock up to a communal desk and plug in their laptop.
Yeah, and you might not have the same desk, all day or even all week or in the same part of the building, whereas other arrangements, that you're getting 50 desks on the second floor and they're all banked together.
Right. And anything else to look out to make the distinction?
Yeah, so one of the other things that we would consider is whether or not there is an ability for the landlord or the service provider to relocate the occupier from one space to another. So, like we said, if you go in and you know that you're at desk 1 and you've booked desk 1 and you can't be moved, that would be a strong indication that an arrangement is a lease and not a license. A lease needs a demise certain, so if you think of 100 desks on the second floor of a suite of a building, that would be much more likely to be a lease. But again, it's not a definitive answer on that point, so just because a document reserves the right and the ability for the landlord to relocate an occupier, if it doesn't happen or it's unlikely to happen, then again that would render the document more likely to be a lease. So it's a fine line.
And quite often you see that, that talk about relocating, don't you, in license documents? And actually people are just never relocated. So the words mean nothing, it's just a sham. And if there's nowhere to relocate them, if you've got nowhere else to put 100 desks in your building, then actually the saying you can relocate is nonsense, really, isn't it? It's just pretend. Okay, so that's what I have to think about whether it's a lease or a license. But why is that so critical? What are the consequences of it being one rather than the other?
So it goes back to what protection and provisions are available to the occupier, depending on the type of document it is. So one of the first things that's relevant is security of occupation and how the transaction is structured. So as an occupier, a licensee doesn't have the same protection as a tenant under the lease. So if your provider holds the property as a leaseholder itself, which is more often the case, and that lease is forfeited by the landlord up the tree, then the licensee occupier won't have any right to apply for relief against forfeiture and to fight for the right to stay in occupation. Some of the providers are seen as too big to fail, and that may well be the case. But in our experience, the vast majority of operators only have a few sites. Some are still testing the market, as this is quite a new concept. And in doing so, they're incurring significant liabilities as they start up, both in taking on the space and fitting out the buildings to the specification. So as a licensee, your occupation is only as good as your provider's covenant.
That's an interesting point what you say about actually that the provider of this instant snazzy office may be a tenant themselves. So you do have to consider the terms of their lease, presumably, whether they're allowed to let you in, whether they're allowed to allow informal occupations, whether the use clause allows you to bring in your pet dog and your beers on a Thursday. Actually, there's that kind of consideration, isn't there?
Yeah, there is. So you'll all be aware that in a lease there can be restrictions on underletting provisions and sharing occupation and how that's managed and how many people can occupy a particular floor of a building, etc. There might also be restrictions in the use, so it might just be straightforward offices, but there may be restrictions on the type of office that it can be used for. And I've also seen in some recent office transactions that I've been doing for corporate occupier clients where they've been taking larger spaces in a building, but landlords have been including prohibitions in those leases that they can't be used for that type of service office, flexible leasing space. That's not what the landlord wants that building to be for.
So actually, merely being there might put your provider in breach of their lease.
Yeah.
You merely being there might undermine your security of occupation.
Yeah.
Right. And the other consequences?
So security of tenure is another thing that we would always consider. So the Landlord and Tenant Act 1954 only applies to leases and not licenses. So if you are a licensee, you won't have any right to stay on at the end of your first contractual arrangement coming to an end. There won't be any right to require the grant of a new license or any right to ask the court to set a market rent. That said, where the co-working arrangements are leases, and that's accepted in the hybrid or flexible leasing space, we find that the providers usually require the parties to contract out the lease from the security of tenure provisions, and this is seen as a catch-all preventative measure to ensure that you don't acquire the renewal rights under the 1954 Act. And that even applies where arrangements are seen as licenses as well.
So actually, the difference between a lease and a license regards 54 Act, a license you don't get 54 Act protection, but in these kind of co-working occupational arrangements, you're probably not going to get 54 Act protection anyway because your provider will require you to contract out in the first place.
Yeah, and that goes to the very nature of the document, it being flexible and no one having to go through that 54 Act renewal process.
Right. Okay. And then lease and license, and there's always a tax issue, isn't it? Things always come down to death and taxes.
Yeah, and this concept is no different. So the question of stamp duty land tax or land transaction tax in Wales is still relevant to these arrangements, and it's a question of whether or not you pay it. So SDLT isn't payable on licenses as they aren't an interest in land, whereas it is payable in respect of the grant of a lease. So when you look at the nature of the property, the number of desk spaces and the people that are being employed, whether it's on exclusive floors or an exclusive area, however you want to call it, the taxman is going to be looking at those points and consider it a lease and not a license, and therefore that's going to give rise to payment of SDLT. Now for smaller areas, for smaller numbers of staff who are moved around frequently, it would be more justifiable to classify that arrangement as a license, and therefore that would mean that SDLT isn't payable on that license fee.
And that can make quite a difference, can't it? Some of the costs associated with these areas, it's chunky money, it's chunky license fees / rent / whatever you call it. So the SDLT must be quite considerable to choose whether or not to pay it.
Yeah, so if you think that the license fee is the inclusive figure for all your services and all the facilities that you're taking advantage of, if there is a possibility that your arrangement is a lease, that will be a hefty SDLT liability. And I've seen clients that I've acted for, and the same client has taken a different view on some of its lettings. So on one, it did distinguish it as a lease and made the SDLT payment, which was quite sizable. And then on another one, it determined and took the view that it wasn't a lease and it was happy to accept the licence and not paying SDLT. So it really does come down to looking at the facts on each particular one.
And with SDLT being a sort of self-assessment tax, isn't it, and deciding whether or not it's payable in the first place, the risk all lies with the corporate occupier, doesn't it, really?
Yeah.
And I think what's interesting is that these agreements you often see, they're very much termed as licenses, or even the more casual membership agreement, that there'll be something in them that says this is not a property right, this is only a license, you can't register it at the land registry, for instance, you're contracted to do that. But then somewhere in them there will be a line about how the occupier is responsible for any SDLT that's payable, and they may even go so far as to put in provisions to contract out of the 54 Act. So on one hand the document is stressing the fact that it is a licence, and on the other hand taking steps to avoid the consequences of it being a lease. So they're internally contradictory, aren't they, really?
Yeah, and it's a difficult decision for corporate occupiers to make, so that's where we can help.
That's the nuance. So looking aside from real estate, though, looking a bit wider, are there legal issues to consider beyond just real estate ones? Do we have other factors to take into account when deciding or not to go with shared space?
Yeah, there definitely are, Caroline. One of the other issues that we would always recommend that our clients consider is around the health and safety of your employees. So you may not have sole control of how the working environment is run and managed in these type of scenarios. How people come and go, how they behave, consistency of employee policies in terms of standards of behaviour and working practices and hours that they keep. So that's something as an employer, just because the people aren't in space that you exclusively control, your responsibilities don't change on that front.
Right, okay, and beyond health and safety of people, what about stuff and information and client confidentiality?
Yeah, so security and confidentiality is really, really important in terms of the information that you hold on your employees and customers, but also in terms of the projects and the paperwork that your employees have access to. So, for example, in the shared working scenario where you have a desk and you get up from your desk and you go to the printer and you pick something up off the printer, who has seen that on the printer, who's seen the papers around your desk, whereas in the more traditional scenario, anyone that's in that space is one of your employees, so there are less concerns. And also with GDPR, a year on, we have seen the implications of that legislation. So that's definitely something to think about. Other things that need to be considered are security arrangements in the building. So are there facilities for people to lock away their papers? Also more valuable things such as laptops and mobile phones, and just from a general theft prevention policy as well. So the wider legal responsibilities for an employer don't change just because you've decided that you're going to enter into one of these arrangements.
Okay, so all that to bear in mind, really. So with the sort of variety of options available and the different ways of occupying, do you think actually, is this the end of traditional commercial leases as we know them that I've been doing for 20 years?
No, Caroline, I think we're safe to say that there's still a future for commercial leases. I would say in my experience, these have been exclusively linked to the office sector, and the practice of co-working hasn't yet spread to the same degree and extent in other areas such as industrial or in the retail sector. Although we have occasionally seen bonded warehouse space or data centre sharing, or you mentioned service providers, that type of scenario. Also, we'll all have seen pop-up retail arrangements coming into place around particular peak trading times, and it's those type of arrangements in those sectors that cross the lease license divide. So I would say that co-working in all its forms widens the choice available for corporate occupiers, but longer term, businesses will always have a requirement for dedicated space where its employees can be. And the short-term nature of these co-working arrangements wouldn't suit that type of planned occupation.
Okay, so for the long haul, perhaps we're still with a traditional commercial lease. Okay, I suppose it's wider choice for all then, isn't it? Yeah. Okay, we'll wait on the line a couple of moments to pick up any questions. One question that's come through as we were talking, possibly a rather pessimistic question. Could the taxman consider occupation to be a lease, but on the legal challenge decide that the court decide it's a license, so you get hit by the tax, but you don't get protection? Well, I think that's a possibility. So if you entered into an agreement and the taxman then investigated it and held it to be a lease, then yes, you'd have to pay your SDLT. I presume you wouldn't have paid your SDLT at the time. You were rather hoping that it was a license, so you'll be in for interest and penalties too. And then it would be at the end of that arrangement that possibly you would say, well, I've paid tax on it now, it's a lease, I'm going to claim 54 Act protection. That actually the provider of your occupation would then try to argue, but no, I agreed it was a license, and you and I agreed it's a license, and just because you had to pay tax on it, kind of not my look at. So I suppose that issue would then go to court. I would like to think that, when considering whether or not arrangement has 54 Act protection, the same considerations by court as to the lease license distinction would be the same considerations that the taxman took. But I don't know if we would ever know. So I suppose there is a possibility. I'd also like to think that actually if it was then later found to be a license, you might be able to claim your tax back. But it's never going to be easy getting SDLT back once you've paid it, I don't suppose.
And also, if it was determined to be a lease, most providers, if there was any possibility of that, they would have contracted it out.
Yeah, that's true. And I have a feeling too, and I really can't remember off the top of my head, but I have a feeling that if you've paid SDLT by mistake, you can claim it back, but there is a time limit for that. I think it's quite generous. It might be several years, so that might not be an issue here, but at some point it's just going to be too late to reclaim. I think I've come across that before. Right, next question. Having a look. Has there ever been a situation, here we go, where a corporate occupier has got it wrong and they thought it was a license and hadn't paid SDLT, but it actually was a lease and then had to go back and pay SDLT? Well, I'm sure there has been. That would depend on, I suppose, somebody finding out about it, wouldn't it? HMRC investigating. But we have heard of HMRC taking a bit more of a view on, taking a view to investigate some of these arrangements, because of course the SDLT payable on leases is quite chunky now, and the more that people move towards licenses, the less tax the revenue will collect. And certainly in respect of sort of data centres where all the arrangements for sharing are by way of licence, I think there has been some concern around there and some investigation by HMRC as to whether or not those arrangements are truly licences or whether they are leases and tax should have been paid. So if there haven't been as many examples yet, I'm sure there will be more going forward. That's the questions for now. Jane and I will just go on mute for a moment and to give people an opportunity to send any more questions through. Otherwise, thank you very much for attending. As I mentioned, the recording will be available in a couple of days on our PROPcasts webpage. If you have any further questions on the issues raised today, or would like to give any feedback on the PROPcast or make any suggestions for the next kind of PROPcast you want to see or the next topic you want us to raise, then please do feel free to get in touch.